Hello everyone, you should all be filtering in. I am just making sure everyone's admitted. So if we just allow another few moments just to make sure everyone's managed to log on okay. Right, I think everyone is in. So what I have done, just in case anyone does get disconnected, is I have taken off the waiting room so that if you do to get disconnected, you'll be able to log straight back in and you won't have to wait for one of us to notice if you're waiting around. So I think the numbers have stabilized. I think we've got everyone here. It's an amazing turnout today, I will add. So it's great to see everyone. Right then, we will make a start. So welcome everyone. You should all be here for dismissals and getting it right. My name is Linda Gamester. I'm an employment solicitor and I'm also head of our employment team here at Bhayani Law. My colleague Hannah Haywood will also be presenting today. She's also on my team and one of our employment lawyers. So there we go. So just a little bit about us. Hopefully you've all been to some of our events before. If you haven't, welcome. It's great to see new faces. But we are an employment law firm and we specialise just in employment law and HR. We cover all your employment needs. We also cover some commercial work as well. So if there's anything you want to discuss that you see on this screen, including health and safety, please get in touch. We are award winning, so I'm going to add that in. Yeah, we are proud of what we've achieved. We do this by offering training. We've got amazing reviews on Google, so please check those out, see what our clients say about us. And of course, we do want you to get in touch to have a chat with us if there's anything that you feel we can be helping you with. So we have been doing employment law a long time. As I said, it is what we do. It is what we specialise in. And what we've identified is we've created a wheel. These are the key things that we think are important for an employee journey. And also the key to you being successful employers. So that includes being compliant. It includes your contracts, your handbooks, culture. I think we all know now, particularly post-COVID, culture is so important. Our employees are looking for so much more from our businesses. It's not just about what you offer in terms of a financial package now. Are your employees happy? So culture is a key one here. Live issues, unfortunately, even the best employers have those niggly issues. At any point, you will need to be dealing with disciplinaries, grievances, capabilities, and unfortunately, tribunal claims. So they are part and parcel of the employee journey and also what we do here. Workforce planning, again, we know that this is a tricky area for you guys at the moment. I am going to be passing you to our recruitment team shortly just to kind of touch on some of those issues. But workforce planning these days is so important to ensure that you've got your succession plans. No one is a key to your business. If they leave, everything's going to come crashing down. You know, you need to make sure that everyone's in the right positions, everyone's doing their jobs, and you're evaluating that as well. Comes under all your workforce planning. Training and events. So training particularly now is an important aspect for employees. We are finding that employees want to know how you are going to develop them, what their career path's going to be. Everyone wants to now expand their knowledge. So training, again, a key element. It's something that we particularly focus on because obviously knowledge is key. HR software, so you can save yourself lots of time and efforts and pain of spreadsheets by getting yourself some HR software in place. It's not only a key place to keep your records, but will also help you with things like absence management, going back to those live issues, making sure you're identifying those issues early on. Your HR software is going to support you in doing that. Health and safety underpins a lot of what happens in the workplace. You get it wrong, it is costly, not only in terms of finance, but also staff morale, going back to your culture, going back to your live issues. It's such an easy thing to get right and get in place. So health and safety, again, important. And then you've got all your other things. So Have you thought about, do you need a little bit of extra support? Have you got all your background contracts in place? By that, I mean your shareholders agreements, your director service agreements. It's very easy to forget about organising that top level of your business. And then finally, recruitment. Recruitment is a difficult one at the moment. I think everyone will agree. It's easing, it is getting better, but it has been so difficult to get people in the right sectors. And I did overhear the other day on the I think it was a television program saying that they're estimating that between 600,000 and possibly maybe even up to 1 million 50 to 60-year-olds retired early after COVID, and that has contributed to this skills gap, because we've seen a vast amount of skilled people leave without training up our next generation. So on that note, I am going to pass you to Zoe, who is our recruitment manager, and she will just talk you through a few of the issues that we're seeing at the moment in recruitment.
Thank you, Lindsay, and hi everybody. So my name is Zoe Johnson and I'm the head of recruitment here at Bhayani Recruitment. So we are a sister company of the Employment Law Service and HR Service that we operate here. Now, we do operate across many different sectors. So whether it's board level appointments, charity, office and professional, HR, there's lots of different sectors that we specialise within. And just touching on what Lindsay said, I think it's really, really crucial to be reviewing your recruitment processes. So both from an internal capacity, but your external services as well. It is easing. So you're right, Lindsay. People are moving now. People are looking for work, where we've seen people a little bit hesitant. But what's actually created now is that candidates are surplus at the moment. So we have lots of candidates, but not enough candidates for the roles, which is resulting in candidates being able to be a little bit picky about where they want to go and what that company offers. People have reevaluated their circumstances, again, going back to the COVID situation, they've thought about what's important to them, and culture is a massive piece of that. The one thing I'm going to say about what we do in terms of recruitment is we're not just a typical recruitment business that's going to send you a candidate across and, wait to hear back. We're not a recruitment business that's just going to advertise your role online. You can do that yourselves. That's something that's really easy and anyone could do that. What we actually do is understand your business. So we understand the culture, we understand the structure of your business. We really get to know you and become an actual extension of your business. But what we also do is we create a very proactive recruitment service. So we don't sit and wait for candidates to be in the open job market. Good people, as we all know, are very well looked after and are comfortable within the company that they're working within. So what we do is we actually proactively recruit. So we test the whole of the market for you as an employer, for you as a hiring manager, to make sure that you are really getting the very best person that you can for a role. It is easy to advertise a position online, and hopefully, there will be lots of applications, but it doesn't always work as easy as that. And I think right now that is where that external recruitment service comes in. Candidate management is key at the moment. And I have a saying that it hasn't happened until it's happened. So until that person comes through the door, they haven't joined you. So, you very may well get to offer stage, but there's a lot of within that process as well. And that's something that we can help you with. So if anyone's got any needs, please reach out and we can discuss, your current practices, what you're doing at the moment. We can offer any improvements, but we can also help you fill any vacancies that you might have as well. Thanks very much, Lindsay.
Thank you. And the other thing just to mention that is just a little bit different about our recruitment service, that actually 10% of our profits do go to charities. We want to give back. We want to change the world of recruitment. It can be such a negative area. We want to turn that on its head, not only in terms of the service we offer, but also giving back to our communities. So without further ado, let's move on to why we're all here. So as I said, you should all be here for dismissals and getting it right. I identified to you in our wheel that live issues, things like disciplinaries, it's part and parcel of what we do. And getting it right is the difference between having happy staff, having happy culture, retaining staff that you want to keep, and losing staff through bad morale, and unfortunately through tribunal claims. So we're going to cover fair reasons for dismissal. We're going to do a little about what procedures look like for each of those areas. We're then going to have a scenario, just so that we can give you guys a chance to go into a breakout room, have a little discussion, and look at a scenario which we see very regularly. And then also we're going to do some other considerations around dismissal. I appreciate this is a very broad area. We are only going to skim the surface of this. We're only touching on all the key points. If you have any questions, please feel free to use the chat bar. Other members of my team are here today, so they should be able to pick up those questions and answer them as we go along if we can. There'll also be time at the end to ask questions as well. But if you hear anything today and you think, I need to know more about that, I need to know the ins and outs of how I do a capability dismissal or how I assess conduct, then stick around till the end, because we've got some other amazing training courses available which will go into depth on those. But today, as I said, we are just skimming the surface. So I'd like to introduce you to my colleague Hannah, who is going to take us through today's topics. So bear with me, Hannah. I'm just going to pass you over control of the slides.
Thank you very much, Lindsay, and thank you everybody for joining us today. As Lindsay said, we've got some great numbers, so that's fantastic. Thank you. I think, do I have the power?
You have the power.
I have the power. So essentially, there are only, I've gone too far, 5 fair reasons for dismissal. These are the 5 key things that employers should be looking at if they've come to the decision that unfortunately we're reaching the end of the road. This obviously isn't the first step that you want to be looking at, and there are a number of key considerations for each of these reasons, but these are the main topics that we're going to cover today, the potentially fair reasons. So the first one obviously is conduct. If somebody commits an act of misconduct, sometimes gross misconduct, it may be likely that you want to look towards dismissal. Those are types of things such as theft from the company, violence, general misconduct that clearly is not acceptable within a workplace. Capability, sometimes these can be slightly intertwined, but they are very different and need to be treated differently. So that's when an employer decides or believes that their employee is now unable to do their job properly, whether that's through ill health, whether that's through poor performance. Have they just decided that, you know, this isn't the job they want to do anymore? They've stopped trying, they've stopped meeting their targets, those types of examples. We've also got redundancy. This is often kind of one on its own in terms of dismissals. You're closing an area of the business, you've gone through a restructure and decided that there's certain job titles that are no longer necessary or don't fit this new structure of your business, and that post or that position is now redundant, and therefore unfortunately that employee's employment is then to be terminated. Again, a different process completely that needs to be undertaken with a redundancy. Statutory restrictions, these can also be identified as illegality. So for example, you have a delivery driver, they lose their license, they're no longer able to undertake their job legally. It would be illegal for them to undertake their job, and for that reason their termination arises. And then we have some other substantial reason. This is sometimes referred to as an SOSR dismissal. It's generally a catch-all situation, whereby if you don't really slot into one of those other 4 boxes, this might be something you want to consider. This is much more of a rare dismissal. We don't see them half as often as we see the others, and there are some considerations that again we can look into when we go through that. So generally speaking, in order for a dismissal to be fair, you need a potentially fair reason plus a fair procedure. Now, this test of reasonableness for the fair procedure, they identified, the courts, that it must fall in the band of reasonable responses. So would another employer make the same decision as you? Would they respond the same way that you did? Looking at the reason and the procedure together, we often see, for example, somebody has committed an act of serious misconduct and the employer goes, no, that's it, done. After 20 years employment, done, I'm not having any more. And they've not followed a procedure and they're sacked instantly. and that can still amount to an unfair dismissal because there is no fair process there. It very well may be that that is an incredibly fair reason to dismiss, but you still need to follow that procedure. So again, that's something that we're looking at because of the importance that it's given. It's almost a 50-50 weighting with both the reason and the procedure. I think we just had a question pop up, and I think we will definitely be able to send the slides out after 100%. I think you just need to, at the end, I think you can email one of my colleagues and they'll send it out to you. No problem. So tackling the first topic, conduct, what might this include? So it may be a single act of serious misconduct, usually termed as gross misconduct. As I said, violence often, you know, there's been a physical assault at work, that would be a serious act of gross misconduct. Or it may be a series of acts that are less serious. That could include disobeying a reasonable request, a breach of certain terms of the contract, mutual trust and confidence, theft or dishonesty, if somebody, you know, the classic been stealing from the till, something like that, unauthorised absence from work, violence at work, alcohol or drug abuse. That also, as I say, though, does potentially need to be treated as an illness. So that's maybe one that you need to take specific advice on. Repeated poor attendance, those types of things that they are consistently and deliberately doing something that they know is something that they should not be doing. That is when you're likely to amount to a conduct charge. Now, how would you deal with this? Potentially looking at disciplinary action. So we would always advise that you investigate any allegations of misconduct. So that might include witness interviews, CCTV footage, interviewing the employee in question during an investigation meeting. So bringing them in, asking them, is this true? What is your version of events? Do you have any mitigating circumstances? You know, tell me what's going on. Is there anything else that I don't know here? You may need to consider if suspension is necessary during an investigation. So suspension should never be seen as an act of disciplinary alone. It should always be a way of you're being removed whilst we investigate this so that nothing else can be tampered with, looked into, and they would always usually be paid during that period of suspension. So again, it's not we've already found you guilty, but we just need to look into this and it may be necessary that you're not around whilst we do that. You may then decide that disciplinary action is required. So you'd have a further disciplinary hearing. That was when you then would consider, you know, do they have any warnings on their file? Is this the last straw? Is there a series of misconduct offences? They've got a written warning. They've had a final written warning. They're done. You know, we've really got to the last straw. Is this the first time they've ever acted out? And you think, actually, this is really not like them. And we've never seen this type of behaviour before. That might be something that you want to consider. Is it worthy of a warning rather than moving to dismissal? And then if you do decide that dismissal is the relevant course of action, are you dismissing with notice or without notice? That might be something that you want to look at. And then also the contractual terms. If you do dismiss with notice, would that be paid in lieu? Would they be working their notice? Would they be placed on garden leave? These are all things that would potentially be relevant dependent upon the allegation of misconduct, dependent upon the employee and the business and what the business can afford to do. So again, these are all quite specific situations for the specific event of a misconduct disciplinary. The next one we'd be looking at is capability. So this in general tends to fall into two main groups. Is it somebody's poor performance? As I said earlier, have they just kind of given up? They've really lost the will. They don't want to be there anymore and it's showing, you know, they're not hitting their targets. They're not doing as requested. Or is it actually somebody's ill health? That ill health capability dismissal, we could have a full hour going into the kind of pitfalls and the potential risks of a capability dismissal. You could be looking at discrimination claims under the Equality Act. Should their ill health be protected as such? Or it may be that they've actually been off sick for an extremely long time and this is not something that the business can sustain any longer. I know there's generally an indication that if somebody's off sick, you can't do anything, you can't dismiss, you can't invite them in to discuss. That's not necessarily the case, but it is slightly more high risk. So we would always advise taking specific advice if that is a situation that you're found with and you want to be able to handle, you know, with the lowest risk possible. So considering somebody's poor performance, Generally speaking, you know, you will have to follow a process. There is no quick fix. We often find that somebody will come to us and say, oh, well, I told them they needed to sort themselves out 2 months ago. And I told them that they needed to, you know, give themselves a shake and figure out what they were doing because their attitude just wasn't in the right place. But there's nothing recorded, there's nothing documented, there's no actual warnings on the file of that employee. And so you can't just turn to dismiss straight away. You need to be able to show that you have given them the time to improve, that you've potentially looked at a performance improvement plan, you know, set targets over a set period of time. This is what I want you to do. This is how we're going to measure you able to do that. Is it sales targets? Is it something that you can look at and say, right, in April, you were here, in May, you were here, in June, we want you to be here. That is going to be a fair and measurable way to then support your dismissal when it comes to July and you go, okay, you've really not hit where we need you to, and it's going to support your decision to dismiss and make it much safer. We always recommend that you keep records of each meetings and each target set. And as I say, it may be something that you want to consider long before a dismissal would become necessary. So even before you get to the point of thinking they're not where they need to be here, it's not working out, you need to have that paperwork in place so you can say, oh, your last appraisal, this was something we discussed. I think it can be quite commonplace for employers to be quite polite about appraisals and say, oh, yeah, it's great, you know, you're coasting, everyone's just getting on with things. But actually, if you take those appraisals or those one-to-ones quite seriously and you have those measurable targets, you can record and say, you know, we asked you and we gave you a heads up at the last time that you weren't where you needed to be, and 6 months down the line you're still not there. That's going to make things a lot quicker when you do decide that it might be something that you want to do in terms of a removal from the business. Redundancy. So as I say, this is kind of one on its own in terms of redundancy, and again we could probably have a full hour on each of these fair reasons. But redundancy generally is a dismissal on the grounds that the employee is redundant, and that post is no longer there or that post is no longer necessary. So that implies it's the whole of their role or the main substance of their role, the main part of it. You may be closing a department, you may be closing a full office, you may be just downsizing in your department and therefore you're going from 5 roles to 3, for example. And you will need to ensure that you're following a fair process. This is probably going to be the process that is mainly looked at if it was ever tested in an employment tribunal. They don't tend to look at the reason why you need to make redundancies. It's widely accepted that businesses unfortunately have to at times, but it's the process that would be tested. So a redundancy is to be considered fair if that full process is undertaken, but you must act long before you are going to make anyone redundant. You need to make a plan and you need to record that plan. Where are you and where do you need to be and how do you need to get there? So documenting what posts are to be made redundant and what the business case is for that. You'll then need to inform all your employees who are at risk of redundancy. So even if they're not all going to be made redundant, if they are in a pool of being considered at risk, then they need to be informed of that. And again, we would always advise that that is done in writing, so you have record. You'll then have to undertake a consultation process. That's where the employees are invited into a meeting. They're given the opportunity to ask questions. They may potentially say, oh, well, what about that job? What about that job? That might be something I'm willing to do. Or I know I work 5 days, but I'd be happy to drop to 3. They may present alternatives that could prevent a redundancy occurring at all. So it's got to be an active and a true consultation, not just on the face of it, we're inviting you in because we have to, tick in the boxes. It's got to be one of those conversations that is generally a backwards and forwards between the employee and yourself. Again, those meetings we would always advise to be recorded and to make sure that you've got accurate notes of what was said in those meetings. The post must be redundant, not the person. We often find that employers can come to us and say, I'm sick of them, they're not doing what they should be doing, I want to make them redundant. If they're not doing what they should be doing, it's probably going to be a capability, it's a performance matter, not necessarily a redundancy. And if redundancies are manipulated in that way, then the true reason for the dismissal may come out in the wash if they do pursue a claim. It does make the redundancy process less trusting, and we would always advise to be as transparent as possible with those processes, because they're generally unpleasant for the employer and the employee. If they have that bit of transparency and can see that you're working with them, it makes everybody a lot more susceptible to that change. Illegality or statutory restriction. So this is where the employee could not continue to work in that position without either themselves or the employer potentially breaking the law. So if somebody doesn't have the right visa requirements to work in this country, as I said earlier, if somebody loses their license and their job is exclusively to drive a lorry or to drive a bus, it would be breaking the law for them to do that job. That is a relatively straightforward, as straightforward as they can be, dismissal, in that you have no choice but to remove them from post. It isn't going to be something that you can continue working with them. And as Lindsay's pointed out in the comments, we would suggest reviewing the contract to look at pile-on suggestions should that be necessary, so that they are entitled to their notice and can be provided with it, but they're not going to work it, because you can, from that point onwards, as soon as you have knowledge of that, you can no longer employ them fairly or legally. So some other substantial reason, that was really spooky because I didn't press that button, so I'm not sure how it came back through, but some other substantial reason. SOSR, as it can sometimes be referred to, as I said, is a catch-all reason often for somebody to fairly dismiss somebody else. It's rarely used and only when necessary, only if there is no other reason that you can slot in elsewhere. I think the most common one we see with this would be third-party pressure. So if you employ somebody but they are permanently posted elsewhere in someone else's business, and that third-party business says we can no longer have them for whatever reason that is, if you have nowhere else to put them, then unfortunately it would be an SOSR dismissal. You have a job for them, but you've nowhere to place them, and therefore their employment would be terminated at that point. With SOSR dismissals, because they are so rarely used and very, very case specific, dependent upon the facts of the matter, we would always advise that you take advice before dismissing anybody on that basis. Especially considering potential discrimination pitfalls. So if you just don't get along with that person anymore, it may be that an SOSR dismissal is necessary, but you also don't want to fall into the areas of potential discrimination because you've not realised that they're actually the only woman in the business, and that's why you don't quite get on, or whatever that may be. It is going to be a bit more risky for you. So, your turn. I know that was a whistle-stop tour through all the potentially fair reasons, but we are going to pop you into breakout rooms now. I'll just go through the scenario, so if anybody's got any imminent questions that they don't want to discuss in the breakout, then they can. But essentially, this employee has 3 years service, but they've been underperforming for the past 3 months. You've not raised any issues with them formally, but you have been meaning to get round to it. You've noticed it. You've just not had the chance. You have, however, had a chat about it at the work social event last week. You told them they needed to book up their ideas because they're just not doing what they should be doing. Yesterday, they sent an email to your entire customer database, which included confidential price lists that have yet to be approved. You don't believe they did it intentionally. They weren't paying attention, and it was due to their negligence that this occurred. You decide that you've had enough's enough, and you invite them to a meeting to discuss that email that they sent. However, once you sent that invitation, you received their sick note. They're now signed off sick with work-related stress for the next 2 weeks. You want to get this dealt with as soon as possible. What are your best next steps? So I think in each breakout room, you should have one of us. So we can obviously have a chat about what we need to be thinking about, what kind of things would be the risks factors, and then we can all come back together and see what we've come up with.
Okay then, so if I have organised everything correctly, Jay, you'll be in room 1, Hannah's room 2, I'll be heading up room 3, and Ellie's in room 4, Nikita's in room 5. So I'm going to open all the rooms now. We'll give this 10 minutes if that's okay with everyone, and then we can come back and just share some ideas together. Okay, right, I'm opening all the rooms. I'm going to Right, everyone should be filtering back. Let me just check. We've got everyone. Oh no, we're still missing some people. Some people may be finishing off some riveting conversations. I know my group was really good. It's been an interesting one.
Yeah, we had lots of good conversation in our group.
Yeah. I think we're slowly coming back. We're up to 44. Are we still missing a room? Yeah, just another second. It's ticking up. This is always the gamble with breakout rooms. You feel like you lose people along the way. But I think we're about there. I think everyone's managed to get back who's going to return. If we've lost people on the way, they can log back in and join us. But as far as I can see, everyone's made it back to the main room. So I'll hand back over to you, Hannah, and you can talk us through.
Yes, thank you. Well, first of all, can we have a bit of feedback from the breakout rooms? So before you go on mute again, Lindsay, what were the kind of main things you were looking at in your group?
Well, so things that we identified in ours was firstly that 3 years service we thought was key. 2 years is obviously at the point where an employee is protected against unfair dismissal, which at that point we need to make sure that we're dotting the I's and crossing the T's in terms of any procedure that we are following. But the main thing that we felt was, firstly, conduct or capability. We didn't feel like we'd done enough on capability to be able to start running with that. We thought it'd take quite a long time. So that conversation that we had at the social event just wasn't enough. And we all generally had quite strong feelings that the misconduct, so the share in the database, was actually possibly gross misconduct. Yeah, it was felt that was the type of person that we probably didn't want in our business anymore, and we might be pushing for a gross misconduct.
Thank you. No, definitely. Ellie, are you all right popping your mic on and telling us about your group?
Yeah, so we had very similar sort of discussions, but what we said in relation to the conduct/capability argument was we actually need to find out what information was leaked. So if it was just the price lists, probably not as serious, but if it was a price list with all of the customers' contact details on there and the clients that they have, then that would be a serious breach of DP that would need to be looked into. One thing that we actually picked up on is this employee has been there for 3 years. As to our knowledge, there's been no other issues to date. So actually, is there something going on outside of work that needs to be looked at first before you have a look at either dismissing or disciplining for capability or conduct? Is there actually something more to this? Is it an environmental factor that needs to be looked at rather than just the issues that they're having at work?
Yeah, for sure. That's something I know we discussed in our group. Have they been good enough for the past 2.5 years, and what's been going on recently?
Yeah,
and to kind of make that change. So thank you very much. Nikita, were you in a separate breakout room?
Yes, I was. So again, we looked at whether or not it would be a capability or conduct procedure that would be more appropriate, leaning more towards a conduct one if it was due to their negligence, where perhaps they were just distracted, they pressed the wrong thing, not looked at what was attached, that sort of thing. But as Ellie said, it'd be a case of looking at the damage that's being caused as a result of what's being sent out to determine the severity of it and what's going to be the most appropriate way to deal with it. Probably looking at a bit of a gross misconduct allegation. May not be moving straight to a dismissal, like you said, and considering length of service, clean disciplinary record, that sort of thing. But with regard to the absence, depending on how long it goes on, is to look at an occupational health report. Is there anything that can be done to get them back into the workplace? Is the stress primarily caused as a result of the disciplinary procedure or the investigation meeting? And just have some welfare checks in the meantime. Looking at the disability angle, obviously work-related stress on its own is not necessarily going to be a disability, but need to be mindful that it could be connected to one. So just keep that at the forefront as well when dealing with the procedure overall.
Brilliant, thank you. And Jay, were you our last breakout room apart from mine?
Yeah, hi. Yeah, so I think we felt that there was an underlying issue with the management here to drop
in this comment and a social, rather than having tackled anything if there have been issues for 3 months, would make the process harder to start because of the way in which it's been raised. But also, what's been going on with this employee. So could there be something that's, either disability related or something external or something internal, possibly, the way that they're being managed or something about their job, the extent of their job or their job role, for them to have suddenly not been performing well. And then we sort of thought about the fact that you'd pull your procedure out, and then how you actually tackle it. But I think we were more concerned really that the process might be a little bit tricky now that they've gone. Can I pose the question as to whether you can carry on a disciplinary or capability process when somebody goes off sick, which I'm sure you'll address, because that's a common question we get asked, isn't it?
Yeah, certainly. So we definitely discussed very similar things to each breakout room, and that was one of the questions that I kind of posed to the group. I think I was kind of quizmaster, but saying, would you be able to carry on? Is this something that you would completely put on a standstill whilst they were off sick? And we discussed it, and I think generally speaking, obviously you need to take it on a case-by-case basis, and look at the specifics of the absence of the individual. But we said in this instance, we'd probably get in touch on a welfare basis initially and say, how are you? Are you all right? Is there anything we can do to assist your return? But make it clear that this isn't going away. This is something that we will be dealing with, because it's unfortunately not something they can bury their head in the sand about. When we looked at the capability versus conduct potential processes, I think we discussed that it may be easier to now go down the conduct route, because again, as the other groups kind of looked at, it's likely this is going to amount to gross misconduct if it is a serious breach of data protection. We're going to have to probably report it to the ICO. There's going to be repercussions. But then we did also kind of come back round to what everybody else looked at, of this is an individual that has been employed for 3 years and it looks to be on a very good basis. So what's been happening? Is it that there's something going on outside of work that we need to consider and speak to them about? So this is kind of something that I was thinking about when we looked at these slides. I don't know if I've got the power back. I have, but yeah, we said we'd think about following the conduct or capability procedure. We've discussed that. Is there a risk to their ill health that could be considered a disability? I think as Jay's group identified, potential risks of disability discrimination, disciplining somebody whilst they're off sick. So there is no hard and fast rule that says you cannot discipline somebody whilst they're off sick, or you cannot continue with the process. But as I say, each individual circumstance needs to be considered one on its own. I think we were all thinking about it in the breakout rooms. That was kind of the first key consideration. Are we stuck, or can we continue? And generally speaking, you can, but it's how you continue with that. And also the reason that they're off sick. I think, I'm not sure who it was in my group, said, if they had been in a serious car accident and were in a full body plaster cast for 2 weeks, it's probably going to be quite difficult to do anything with them or for them. But again, that's going to be taken on a case-by-case basis. So it might also be worth thinking about what timescale are you considering with this process. Is this something that you think, actually, I don't want them coming back to work at all? Or would you be looking at going through the poor performance capability and it being a lot longer to achieve your aims? I think we all decided the informal chat did not help anything. It didn't continue with the matter at all, and if anything was just a bit unprofessional and probably shouldn't have happened at all. And then would you consider a lesser sanction than dismissal? So that probably encompasses, is there something else going on? Is this kind of a first offence? Is this a type of employee that you do want to keep? Have they been a good employee for the majority of their employment? So they're all key things to think about. And obviously, if you have any other specific questions about this scenario or anything similar, then you can drop a question in the chat box or come back to us at the end. I think Lindsay's just covered one of the questions in there at the moment, so thank you, Lindsay. Automatic unfair dismissals. So we looked at that scenario and all identified, I think, relatively easily that They had more than 2 years service, they had 3, and therefore they are protected and are able to pursue an unfair dismissal claim. So we need to dot the I's, cross the T's, and make sure everything stands as it should. Automatically unfair dismissals, there is no 2-year qualifying period. So these are for very specific reasons. So these are dismissals for reasons connected to pregnancy, health and safety activities, trade union membership, whistleblowing, asserting a statutory right. If you dismiss somebody, you may not, at the first thought, think it's connected to any of these reasons, but it may take a general view of the whole situation for somebody to point out, actually, that might be considered whistleblowing. You think they're bad news and they're going to cause trouble, but they've only been here 6 months, so you get rid, and you think there's no more questions asked. But that might actually be considered whistleblowing. They'd then be caught under this automatically unfair dismissal category and be able to pursue a claim without that 2-year qualifying period. So whilst it is one of the first questions you're probably going to think about and look to, what's their length of service, it's not an automatic safe bet if somebody's got less than 2 years. So it's definitely one to think about and consider potentially in more detail. Of course, any kind of discrimination claims, again, a day one right, there's no qualifying period there. So it's not just unfair dismissal that you need to be thinking about if you are to dismiss somebody. The procedure. We've gone through the procedures that need to be followed with a number of these types of dismissals. But the ACAS Code of Practice, which applies to performance and conduct dismissals, can potentially result in 25% more compensation being awarded to the employee should they be successful, if they can show that you've failed to follow a fair procedure. Now, the ACAS Code of Practice isn't a piece of law that says there will be a claim pursued against you and you absolutely have to follow this. But as I say, it can result in 25% uplift in any award. That can be a huge amount, and that can really be costly to a lot of employers, especially the smaller and medium-sized businesses. So it is 100% something that we would recommend that you follow and have policies in place that evidence that you follow these types of procedures. Generally speaking, it's everything that we've discussed. It is a fair procedure. It's investigating the issues. It's informing the employee of the issues in writing, keeping records for their benefit and for yours, conducting a hearing or meeting with the employee and having correct minutes of those meetings, and informing the employee of the decision in writing and including a right of appeal. So should you decide to dismiss, then allowing that right of appeal may again assist you and protect you further if they do choose to go back to the tribunal and to cause further problems if they decide that they believe it is unfair. Written reasons for dismissal. So this isn't just us saying, you know, please keep a record, it's really going to help you out. Employees who have achieved the qualifying period of service are entitled on request to a written statement of the reasons for their dismissal. So if you just decide you're going to dismiss somebody and you verbally communicate that in a meeting, it's not advisable for a multitude of reasons, but if they do then come back and say, I need that in writing, they have the right to that, to be provided with that. Of course, writing can be scrutinised. It's not going to be on memory of what was said and what was discussed. You are committing pen to paper. So you do need to be aware and to be careful of how that's worded and what you've put in that letter to inform them of their dismissal. Employees who are dismissed while pregnant or during statutory maternity or adoption leave have the right to be given written reasons for their dismissal without even requesting it, and regardless of their length of service. So dismissing somebody during their maternity leave or whilst they're pregnant is a whole different kettle of fish of high risk situations. But if that is something that is necessary for your business, then we would always again state that it must be given in writing. So a successful appeal. We briefly touched on whether employees should be given the right to appeal, but if they do decide to appeal against their dismissal, in some cases where they are successful, it may be that actually somebody dismissed them, somebody else will then review that appeal and go, this never should have happened, the procedure wasn't right, the reason wasn't fair. If they then overturn that appeal, the decision is then considered to have vanished. So it's as if it never happened. So as a result, they'll be reinstated, their continuous service will continue to run, and they'll be unable to bring any unfair dismissal claims because it never happened. It was all in your imagination. It wasn't. It did happen, but you obviously recovered that situation. Their pay will also be backdated to cover any period, so between their original dismissal and the outcome of that appeal. That's one of the reasons why we would always advise that appeals are dealt with relatively quickly for the sanity of the employee, but also you do not want to be sat with a huge big bill of backdated pay should that appeal be overturned and the decision go with the employee. It will assist everybody if it's dealt with within a couple of weeks following the dismissal, so that everything can be dealt with and wrapped up as quickly as possible. So what happens if a dismissal is unfair? If you do dismiss somebody and it is considered to be unfair by an employment tribunal, they've taken the claim to the tribunal and been successful, the tribunal do have a number of remedies that they can use. So they may decide to order the employee to be reinstated on the same terms and conditions, or to be re-engaged on different terms. Now, those two options are very rare. They don't occur often because it's usually in nobody's best interest. The relationship has often completely broken down and the employer nor the employee want to continue to work together. And that is something that a judge will take into consideration. Also, often a long period of time has passed from the dismissal to the decision being made by a judge. It can be sometimes a year, 18 months, and a lot will have changed. It may not be practical to then reinsert somebody back into that role. So that's something that they will always look to. So the general award that is given, or the general remedy a tribunal judge decides to go with, is compensation. It's money. It's going to cost people a lot of money. So it's often financial compensation on the basis of their length of service. They'll take into account their wages, what they were earning before, how long they've remained unemployed, have they walked into another job the following week after their dismissal on £5 more? Great. If they haven't and they've remained unemployed for a substantial period of time, and the reason they were dismissed is deemed to be unfair, it could result in quite a hefty sum of compensation ordered to be paid by the employer. So the tribunal are quite slow in providing their statistics. So we've got the period from 2021 to 22. I think it was the last quarter of 21 to 22. There were 630 successful unfair dismissal claims. That does not include dismissal claims that were attached to any kind of discrimination. These are standalone dismissals, and it does not include any that were settled or did not actually get to a hearing. So the real life number of those that were brought in the first instance is going to be a lot more than that, probably double. That is 51% up from the previous year. So they are on the rise, and people are not afraid to sue. It's something that we are seeing much more of. The largest award during that period, you can see on the screen, was £118,000, just over. So it is expensive. It can be costly, and that does not include the amount that the respondent will have paid on their legal fees. So if they have instructed people to defend the claims against them, that is also a cost that they will have to bear. So that is also something to take into consideration. If this doesn't go right, it can be extremely costly. But of course, you come to things like this to make sure that it doesn't go wrong. It always goes right, and you can take advice when you need it. So obviously, you're in the right place, and this isn't going to happen to any of you, I'm sure. One way to potentially avoid that risk is to look at settlement agreements. So sometimes from both a practical and a commercial point of view, it is better to try and reach a financial agreement with the employee. I know often that this can be an emotional point for a lot of employers that think, no, actually, I don't want to pay you a penny. I did everything right. I don't deserve this to be happening. And that might be true. But from a commercial point of view, it may be worth considering. So if an agreement can be reached, then we would always advise that you ask the employee to sign a settlement agreement. That will protect you from all future claims. They cannot pursue you then regarding the period of their employment. And you must also ensure that they take independent legal advice on that agreement. If they don't, it may not be considered to be legally binding, and you may have just wasted all your time and money. We have a lot of times where it's actually not so contentious and the employee goes, oh, don't worry about it. I'll just sign it. I don't need advice. It's fine. Don't worry. No. Make them go and find advice. We can send them to people to go and get advice. It is something that they have to do. There are risks in proposing such a solution, and obviously an employee may not be willing to sign their life away in such an agreement. So hopefully you caught our last HR exchange, because we went over settlement agreements last time. and discuss them all. Obviously, if you do have any specific questions over settlement agreements or terminating somebody's employment via a settlement agreement, then please do get in touch and let us know. It's definitely something we can help you with. If you were busy last time we did HR Exchange, I understand, and it's not personal.
I will just add in there that I believe our last HR Exchange was recorded and will be on our website. So if you do go on our website, look under the training, you should be able to access that if you do want to go back over settlement agreements as well. So
I think that is everything from me. So thank you very much, guys. And I will just pass you through to Lindsay for the last 10 minutes, if that's all right.
Well, thank you everyone for staying with us and listening to that. Thank you, Hannah. That was an amazing whistle-stop tour. It is a massively complicated area. We do strongly advise that you get advice when you need it. You go on the training and you get support. One thing that we offer in abundance is training. We offer support to you guys. We have packages that can help you. But the one thing that I'm so excited about that I hope you can all join us on this year is that we're actually doing an in-person conference. This is going to take place in Sheffield at Kenwood Hall. It's going to be on the 19th of April. And what we are going to cover there, if you bear with me. So we are going to cover our employment law updates. So that is our standard HR exchange that we would normally do for you guys, but we're going to throw it into an in-person event where we're going to feed you, we're going to look after you, you get to meet us in person as well. But we're going to focus more on well-being and those topics that have either been in the news. For example, we're going to do menopause. You'll have seen yesterday that they are not pushing forward with the menopause bill, which is really disappointing. Menopause isn't going away. Women are getting older. There's still going to be the same amount of women in the workplace that suffer from menopause. And as an employer, you have a duty to make sure that you are looking after your workforce. If you are complaining that you are struggling to either recruit or you are losing staff members, you haven't got skills, then make sure that you've got your training all up to date for things like the menopause. You don't want to lose a section of your workforce due to stuff like menopause. Domestic violence, again, a very exciting initiative we've got here in Sheffield. So Sheffield City Council are doing a push now because obviously since lockdown, since COVID, there has been a rise in domestic violence, and this is affecting the workplace. It is affecting your attendance, it's affecting presenteeism, and it is something that employers need to be equipped to deal with. Particularly if you have lots of home workers. A lot of these issues have arisen due to home working. So again, it's something that you need to make sure that you are equipped to deal with. And then we're going to look at some practical advice. So we've actually got one of our very own clients coming to speak, just to say what they've done and what is working for them in terms of well-being, culture, looking after their staff. So it's going to be an amazing day. There's some early tickets, bird tickets still available up until the 13th of February. We have got limited numbers, so please get on and book those ASAP and do not miss out. Finally, I have said to you that if you have heard anything today that has made you think, oh, I need some more help with this, then you need to get some more training. So I'm just going to pass you over to my colleague Ellie, who has been heading up our training initiative, and she's done some wonderful things across Sheffield at the moment in terms of training. So Ellie, I don't know if you want to unmute yourself and say a few words.
Yeah, thank you for that, Lindsay, and thank you, Diana, for such an amazing session today. It's been really useful for you all to hear about the sort of 5 fair reasons there, but it doesn't stop there, and there's so much more that you can learn. So over the past year, we have really expanded what we offer to our clients and those within the region to do with how you can develop and train your staff. So we offer training to businesses and charities, but that doesn't just mean the business itself. It includes groups within a company, so management teams or individuals that you want to develop, but it does just look at those individuals as solo people rather than just groups. So we do offer bespoke in-house training designed to help the business or charity understand more about embedding sort of a wide range of HR skills into the team and competencies that you actually need to achieve them. So showing ownership and visibility about HR training and employment law really does ensure that you are, one, compliant and protect yourselves from potential claims at the tribunal, but also it shows that you're adding value to your staff, and it shows that you're wanting to develop them. And as Zoe said earlier on in today's session, you know, although the market is getting better from a recruitment perspective, the candidates out there are really looking for employers who will provide them with a journey. You know, they're not just looking for stopgaps anymore. They're looking for a company who will bring them on board, who will develop them, and who will create a career path for them. So that's where training really comes into this. If you want to develop your staff, and if you really want to show them how you want to put them on that career path, you want to develop them, you want to help them with their people management, and you want them to become somebody who has management responsibilities within the business, that is something that we can provide you with. A real hot topic at the moment, both with charities and with businesses, is equality, diversity and unconscious bias. And that's something that we're really keen on, and something that we've really pushed over sort of the last 12 months to expand our offering to businesses, because it really is so important, particularly through lockdown and coming out of that period. Everybody was isolated, everybody was working from home. We had to embed ourselves back into the place of work. So in order to do that, understanding what equality, diversity and unconscious bias is really helps staff to be able to come back in. So something that's really exciting for us is we have just become Skillsbank approved. So we are now a Skillsbank approved training provider. So Skillsbank is a flexible pot of funding which helps businesses to provide bespoke, tailored training to meet the needs of your employees. Again, it doesn't just have to be groups of individuals within your workplace. It does count towards just solo individuals as well. So through Skillsbank, we can provide a range of training, HR, recruitment, employment law. And if you are based in South Yorkshire, you can get between 40 to 60% of those training costs reimbursed to you, as well as sort of the Skillsbank funding programme that we are a part of. We are currently looking at getting our training accredited, and we are nearly at the end of that process. So we will become an accredited training providing centre, which means that anybody who wished to book some training for individuals, you can get up to 100% of that funded through the council and through our accredited training. We're currently looking at getting 3 courses on there. So if you did think that any individuals within your business, or having learned and listened to today's session, you felt that you needed to understand more about the individual processes, then these are the training courses that we are currently offering. So we've got an equality, diversity and unconscious bias course next week, which is actually quite popular. A lot of people are booking onto it. It is £95 plus VAT, and it is virtual. So if you were interested in that, then obviously please drop us a message and let us know. But expanding on what Hannah was discussing today, we've got our HR Essentials course there at the bottom. So in terms of the 5 fair reasons for dismissal, it's really important to know what the fair reason is. But ultimately, it's really important to know what underpins that and how to actually manage somebody's performance and somebody's capability at work. So as part of that session, what we'll do is we'll break it down and we'll look at how to actually performance manage somebody and how to go through the process of capability. So whilst it's important to know that the basics, is really key for you and your business to understand the process that you need to follow. So it's really important that you expand further on your knowledge. So if any of this was of interest to you, then obviously please do get in touch, let us know. We've got a full programme of events throughout the year so far, but we are adding more and more and more events. So please keep on top of that. Look on our website, get in touch about Skillsbank and our accredited training, because they are such key programmes to be a part of. We're really proud. It allows you to develop your staff, but also gives you that little bit of help towards it. So it is really important. So please do let us know.
Well, thank you, Ellie. One thing, I know I've mentioned Sheffield a few times, however, we are nationwide, and a lot of the training we have done has actually been outside of Sheffield too. It doesn't matter where your business is based, we can support you. So other ways, we'll have I think I was going to put some questions in, but people have been asking questions as we've gone along, and I think we've answered everything that I have seen. So I may come back to questions, just because obviously we're talking more about how we can help. Just one of the other key ways we can help you guys out is, again, no matter where your business is based, we do have what we call our watertight package, which we become your one-stop shop for all your HR needs. We support, even if you've got HR in-house, we will support you with all your decisions. We help you with your contracts, your handbook. You think back to that wheel that I showed you at the beginning of all those core things that we have identified are important for you and your business. We will cover under our package. It starts from as little as £99 plus VAT per month. So it's worth having a conversation with us to see how we can support you guys. We're not here to replace HR. We're here to support you, to empower you, and make sure that you are doing the best job possible. So after today, please send us feedback. We will be sending feedback forms out by email. On the form, you will be able to request a copy of the slides if you do want them. But reviews, please leave us some reviews. Google, Trustpilot, review solicitors. We want your feedback. We want to know how you found our sessions. We want to know what other sessions you want us to hold, what topics you want us to cover. We are here for you guys, and we want to tailor our programs to make sure we are telling you the things that you want to hear. Also, sign up to our newsletter. There is a QR code there on your screen, which scan in, join our newsletter. We send out regular HR updates. We cover all the latest things that are happening in the news, but also there's lots of ideas, training. We cover so much in that newsletter, so please do sign up if you haven't already. Then finally, a thank you for attending. As we have said today, please do get in touch with us if you have enjoyed listening to today's session. Book onto our future HR exchanges. Come and see us at our annual conference. Book in for the training to make sure that your staff are fully up to date and know what they are doing. Allow us to help you make your business the best it can be and to survive these challenging times. So there's lots of ways you can contact us. You'll see the recruitment number on there as well, and the email if you do have any recruitment needs or just want to chat to find out what the opportunities are out there or how our team can help you. I said I'd come back for questions because we will hang around just for a few more minutes. If anyone does want to ask anything, please feel free to use the chat box, or if you do want to unmute yourselves and ask a question, we're happy to hear that too. But if there isn't anything, I want to thank everyone that's going to be shooting off now. Thank you for coming. Book onto our future events, and we will see you all very soon.